Well, it's too loud. Here is the assignment for your first paper. I posted it. This is not it. I posted it last night, so you know what you're supposed to be doing now. I should have mentioned, I'll forget something every day. I depend on you guys to remind me of where the holes are in this course. I should have mentioned that about office hours, if you have class after this one that you can't miss, I can come in early and meet you before class someplace. Where's the closest cafe to here anyway? Is there one? Where? No, we'll find one. Anyway, if you'd like to see me before class, or have to see me before class, email me at least a day ahead of time and we'll make arrangements to meet before class. I should also have emphasized the glossary, which is in the reader and under resources on DSpace, which will answer a lot of questions. I mean, it's the terms that we'll use over and over again in the course, and you need to know what they mean and you need to know how to use them. So I recommend getting familiar with the glossary soon. Anybody have trouble getting the books or the reader? Everything's available? Yeah. 2 books are missing. The Greenhouse book and the Figures of Speech book are missing? What are you going to say? Where? Oh, really? Well, you can get it through Amazon, and other bookstores ought to have it. Ned's might have it too. I don't know. Let me know if that's a problem, and see whether we can get the publisher to hustle some copies over here. We left off talking about these folks and how they get to be justices of the court, that they get appointed by the president and confirmed by the Senate, and that their tenure is for life. That is, they serve for life during good behavior, which means that there's no term, but they are, like the president, subject to impeachment. And over history, a tiny handful of federal judges, I don't remember a Supreme Court justice ever being impeached. So it's very rare, and you have to assume that the justices, once confirmed, will be there for life. And that's reasonable. People can debate about whether that's a good idea. I think we're the only country in the world that gives its judges life tenure. I happen to think that it is very healthy for the First Amendment that judges have life tenure, meaning that they don't have to be looking over their shoulder at what the people may think about their decisions, and they are liberated by not having to stand for election, for example. They're liberated to do the right thing in very unpopular cases. And First Amendment cases are by definition unpopular, where the speech is speech that the government doesn't want to tolerate, and that if put to a vote of the people, overwhelmingly the majority would say, we don't want that speech in our society, that type of speech or that particular speech. Well, judges who don't have to worry about being elected can do the right thing and enforce the First Amendment. We'll come back to that idea in a while. Oddly enough, with regard to the Supreme Court, yes? It's hard to hear? Thanks for saying that. I beefed up the volume a little bit before and I got some feedback. Let me see how. Sorry? Muffled? No, that's me. It's just an old muffled voice. I used to have a good voice. I could sing to you, but let's try this. I upped the volume slightly. Okay. One of the peculiar things about the court is that there are no formal requirements for being a justice of the United States Supreme Court. To be president, what do you have to be? The Constitution says that there are 2 formal requirements to be president of the United States. What are they? Natural born citizen. Exactly. You got to be 35 years of age and born in the United States, as we know from the controversy about Obama's birth certificate. Supreme Court, no such thing. Theoretically, you could be 16, born in France, and be a member of the Supreme Court. There are no degree requirements. You could be a high school dropout, a high school graduate, and be a member of the Supreme Court. You're not required to be a lawyer to be on the Supreme Court. Every justice of the court inside the entire history has, in fact, been a lawyer. Not all of them went to law school. Back in the early days, the way many people became lawyers was to apprentice themselves to a lawyer and work for a lawyer, and then you could be admitted to the bar after certain apprenticeship. The last one that did that was Robert Jackson, who was a Supreme Court justice in the 1940s, who had been an apprentice. In fact, all of the current justices of the court are lawyers. And, interestingly, on the current court, every single one of them, except the newest, Elena Kagan, was a judge on a federal court of appeals and was promoted from being a judge on the Court of Appeals to the Supreme Court. Well, does this group look like America? Bill Clinton used to say, I want an administration that looks like America. Does this group look like America? I mean, there are some astonishing demographics on the court. There are 6 Catholics and 3 Jews. What? This is an institution that throughout almost its entire history was completely a WASP outfit. There was Chief Justice Taney in the middle of the 19th century, the justice who wrote the Dred Scott decision, was a Catholic. He was the first. And then there were 2 other Catholics on the court in the 19th century. But basically, it was a white Anglo-Saxon male province, the Supreme Court. All of a sudden, we have 6 Catholics and 3 Jews. The Jews are Ruth Ginsburg and Stephen Breyer and Elena Kagan. Everybody else is Catholic. How can that happen? Hard to explain. There is 1 African American, 1 Hispanic, Sotomayor, the first, by the way. There has never been an Asian American on the court. There are, among the current 9, 4 New Yorkers. What kind of geographical diversity is that? Well, they're each from a different borough. Kagan grew up in the Bronx, and Sotomayor grew up in the Bronx, Kagan in Manhattan, and so on. And Alito was just from across the bridge in New Jersey, so he was close. Every single justice on current court, went to either the Harvard Law School or the Yale Law School. What kind of diversity is that? Ruth Ginsburg started at the Harvard Law School. She didn't graduate from there. She graduated from Columbia. She had to go to New York because her husband was being treated for medical problems. Let's look at the individuals on the court, starting with the chief, John Roberts. He's been Chief Justice and on the court since 2005. He, when appointed, was the youngest Chief Justice since John Marshall back in the 1801. He's now 57 years old, the second youngest on the court. He's likely to be there a long time. The youngest, of course, is Kagan. When he got out of Harvard Law School, Roberts clerked for then Chief Justice William Rehnquist. A clerk for a justice, as you'll find in the Greenhouse book, is sort of an intellectual helper. Each justice has, I think the number now is 4 clerks, recent graduates of law school who are the best and the brightest, who go there to help the justices do their research and writing. And that's what Roberts did for Rehnquist, whom he then replaced as Chief Justice when he was appointed to the court. After clerking for Rehnquist, Roberts went to work in the Reagan administration in the early 80s, and then went into private practice, where he earned over $1 million a year. A very successful law practitioner. His salary as Chief Justice of the United States now is $223,500. So in order to take his appointment on the court, he had to take a significant pay cut. He was appointed from practice to the District of Columbia Court of Appeals by George W. Bush, then elevated into the Supreme Court. At his confirmation hearings back in 2005, Roberts eloquently explained the role of the Justice of the Court and used as an analogy an umpire in a baseball game who calls balls and strikes, calls them the way he sees them. Sort of almost a mechanical way of judging that really doesn't capture what a Supreme Court justice does at all. But he went on about the need for judicial restraint. That is, the justices should not attempt to make law or to change law, but rather should decide cases on the narrowest possible grounds, proceed incrementally, don't paint with a broad brush, but just decide what absolutely has to be decided in any given case. And that will, by the way, promote unanimity in decisions. The court has, in his view, too many split decisions, and the ones that are most troubling, of course, are the 5-4 decisions, where just the vote of one justice determines the outcome. And he also emphasized during his hearings the need to respect precedent. That is, precedent, not precedence, but it's precedent. That is, a case that has previously been decided by the court. Under our system, as we'll talk about at various stages, under the common law system, judges are supposed to decide cases based on what has previously been decided. They don't write on a clean slate in every case. They look back, they do their research, they look back to what has previously been decided, look to the precedents, TS. Look back to the previously decided cases and decide whether they govern the case that has to be decided now. And Chief Justice Roberts said in his hearing, that's the essence of our system, and courts shouldn't just go off on their own and write new law. They ought to have genuine respect for precedent. How has Roberts been on the First Amendment? Mixed bag. He has written some good opinions that we will look at. One of them, a case called Snyder versus Phelps. That's the case of the funeral protesters who go around to military funerals with their ugly homophobic signs. That was an excellent opinion that Roberts wrote. He wrote the opinion in United States versus Stevens, which involved what is commonly called crush videos, pictures of animals being killed or mutilated. And he found that the law in that case, the federal law, was unconstitutional. It was a very good, you may not like the outcome in all these cases, but it was a very good First Amendment decision, a strong pro-free speech opinion. On the other hand, Roberts wrote the opinion in the Bong Hits case, Bong Hits for Jesus, which is the Morse versus Frederick. We're going to consider that case in detail a week from today, in which the court decided that high school kids' First Amendment rights are extremely limited, and that when the high school kid in that case unfurled a banner across the street from the school saying Bong Hits for Jesus, and he was suspended from school and punished, that the court decided he did not have a First Amendment right to do that. And we'll look at that case in some detail next week. Roberts also decided another case that we'll look at, a national security case, in which the federal law outlawed providing material support to designated terrorist organizations. And a couple of American groups wanted to provide assistance to a couple of groups, a Kurdish group and a Sri Lankan group, that had been designated as terrorist organizations. But what the American groups wanted to do was provide them some legal advice on how they can get their causes advanced through the United Nations rather than through terrorism and war. And the court decided that the First Amendment did not protect those Americans. Antonin Scalia, certainly one of the most entertaining of the current justices. I'm going to proceed in order of seniority, the way the court proceeds. That is, they rank the justices, the way they sit in the courtroom, and the way they are consulted about writing opinions is in order of seniority. Well, next to the chief, who's not the most senior justice on the court, but since he's chief, he comes first. Antonin Scalia was appointed by President Reagan back in 1986. He's now 77 years old, though he seems to be very hale and hearty and in no hurry to retire. The subject never comes up with him. He's known by his friends as Nino, and his fellow justices on the court call him Nino. He comes from an Italian immigrant family in Queens, New York. Very serious Catholic. He met his wife while he was at the Harvard Law School. Together they have 9 children. He worked in the Nixon administration back in the 70s, and then he taught at Georgetown Law School and then at the University of Chicago. And in Chicago he bought a former fraternity house to accommodate his family. President Reagan appointed Scalia to the District of Columbia Court of Appeals and then to the Supreme Court. He filled Rehnquist's vacancy when Rehnquist was made chief. And his confirmation hearings, these days confirmation hearings are major political battles. Back then his confirmation hearing was nothing to get excited about at all. He was practically unnoticed, and he was confirmed unanimously by the United States Senate. He makes the salary of all of the associate justices is $213,900, $10,000 less than the chief. At Scalia's confirmation hearing in 1986, to avoid any controversy about his views at all, he said, "I do not think I should answer any questions regarding any specific Supreme Court opinion, even one as fundamental as Marbury versus Madison." Well, he kept mum there, but he certainly doesn't keep mum on the bench. He is the most active questioner on the court, interrupting lawyers as they attempt to make their points, saying things that are funny, drawing laughs. He's very caustic, very sarcastic, very entertaining. And he writes the same way. He's a good writer and a persuasive writer, and he is very, very conservative. On the First Amendment, however, as sometimes happens with conservatives, a libertarian streak creeps in. He's a bit of a maverick on the First Amendment. For example, he supplied the 5th vote on the court in one of the major flag-burning cases, where it was a law against burning the American flag, even in protest, and the court said that that violated the Constitution. Scalia did that. He wrote the opinion in a cross-burning case out of Minnesota, where the Minnesota law outlawed burning a cross to scare people, and he said that was unconstitutional. He wrote the opinion for the court, now becoming more controversial in the wake of the Sandy elementary school shooting. He wrote the opinion 2 years ago in the violent video games case, throwing out the California law that prohibited selling violent video games to minors. So he's done some good things on the First Amendment. On the other hand, he has a blind spot on any kind of sexual material. The FCC regulation of the airwaves is one example, which he thinks the FCC ought to be able to regulate indecency on the airwaves. And he's generally bad on matters involving sexual speech. As you know, he's, as a conservative, he is opposed to abortion. He has criticized Roe versus Wade, the abortion decision, at every opportunity, said it was wrongly decided, and he can't wait to get an opportunity to overrule it. So he's anti-abortion, and he's genuinely pro-business. And you see in his concurring opinion in the Citizens United case, which we'll consider in a couple of weeks, the campaign finance case, where the court held that corporations have First Amendment rights to participate in political campaigns. He's very much pro-business, and I came across a cartoon somewhere that quotes Scalia saying, "Personhood begins at the moment of incorporation." He is somebody to watch. Then there's Anthony Kennedy, who was appointed by President Reagan also in 1988. Kennedy is now a fairly youthful 77 years old. He's a nice Catholic boy from Sacramento. Went to Stanford, then to Harvard Law School. He was in private practice in Sacramento for a number of years, and while he was there, he worked for Ronald Reagan when Reagan was governor of California before he became president. And on Reagan's recommendation, President Gerald Ford named Kennedy to the Ninth Circuit Court of Appeals in 1975. The Ninth Circuit is one of a dozen federal courts of appeals. They divide up the country geographically. We here in California are in the Ninth Circuit, which includes a big chunk of the United States. It includes Montana, Idaho, Washington, Alaska, Oregon, California, Nevada, Arizona, Hawaii, and some other islands out in the Pacific. It is the biggest circuit. It has a lot of judges on the Ninth Circuit. The Second Circuit, a well-known, well-respected circuit, sits in New York City, for example. It governs New York and Connecticut. Anyway, there's a dozen circuits. He was appointed to the Ninth Circuit, and when he was appointed, he was the youngest federal judge. He happened to have been Reagan's third choice for an open slot on the U.S. Supreme Court. You American historians, you political science types will know about Robert Bork's adventures with the Senate in his confirmation hearing. Bork was a very conservative and very outspoken man who had written a lot. He had a long track record. He appears before the Senate, and he was not shy about telling the senators exactly what he thought about most issues, including many issues that would come before the court. And there was a big political to-do about that. He was considered by a majority of senators not to be within the mainstream of American legal thought, and he was defeated. His confirmation, he was not confirmed. And then Reagan appointed as a next attempt to fill that vacancy, a judge from the Federal Court of Appeals in D.C., Douglas Ginsburg, and he seemed to be relatively non-controversial until it came out that while he was in law school, he had smoked marijuana. And that torpedoed his appointment. So Reagan then went to his old reliable Anthony Kennedy to fill the vacancy. How's Kennedy on the First Amendment? In my view, he is the strongest member of the current court on free speech and press issues. He's decided a lot of the cases. We're going to look at him. He is the most consistent.